Hey guys, so you're ready for today's May 2nd, 2022, 10:13 p.m. Central Time. So about an hour ago, Politico leaked a SCOTUS document, which is a first draft of the full court's opinion that overturns Roe v. Wade. Okay, so it looks like, based on what I read and everything else, and I mean the actual document I read, not articles. I'm going to show you that document. I'm going to read a few pages. So you know what it says, for one, but also it actually answers a question I've had for years. That question is simple. How is an abortion a constitutional right? Okay? No one's been able to explain that whatsoever. This opinion actually tells you how it became known as a constitutional right. It is not, and it never has been, period, end of story. There's nothing in the Constitution that says an abortion is right. A lot of people who have argued before the courts, though, that I've heard in other stuff for abortions, they argue it's under the 9th Amendment or something like that. And it's not. Here's the deal. Show you the document, right? Let's see. It is Thomas Dobbs versus Jackson Women's Health Organization was the court case. Looked up the court case fairly quickly. Here's the deal. I knew this was going to be a problem for the pro-abortion people. I knew it because of what the other people on the other side of the aisle were arguing. They put the court in a position where either they overturn Roe v. Wade, period, or they say a specific law, which is, they're talking about Mississippi state law, is unconstitutional. They were dumb. This is the dumbest case to have been brought before justices if you wanted to keep Roe v. Wade, period. And I'll actually show you in the SCOTUS document where they actually say stuff. Okay, so this case was dealing with the constitutionality of a 2018 Mississippi state law that banned abortion operations after the first 15 weeks of pregnancy. Okay, the oral arguments were heard December 2021. With the decision expected by the end of 2021-2022 term, which is coming up here very quickly. This was circulated, the first draft was circulated through the court February 10th, 2022. Okay, this is what this says. It first answers the question that I said. Where is this constitutionality coming from? Okay. This is where it kind of starts here. It says, eventually the Planned Parenthood of Southeastern Pennsylvania versus Casey, the court revisited Roe, but the members of the court split 3 ways. 2 justices expressed no desire to change Roe in any way. 4 others wanted to overrule the decision in its entirety. And the 3 remaining justices who jointly signed the controlling opinion took a third position. Their opinion did not endorse Roe's reasoning, and it even hinted that one or more of its authors might have had reservations about whether the Constitution protects a right of abortion. But the opinion concluded that the stare decisis, which calls for prior decisions to be followed in most instances, required adherence to what it's called Roe's central holding, quote unquote, that a state may not constitutionally protect fetal life before visibility, even if the holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and the rule of law. So that's how that kind of came into play. Now here's the deal. Paradoxically, the judgment in Casey did a fair amount of overruling. Several important abortion decisions were overruled into the Roe itself was overruled in part. Casey threw out Roe's trimester scheme and substituted a new rule for uncertain origin under the states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and undue burden. But the 3 justices who authored the controlling opinion, quote, called the contending sides of the national controversy to end their national division, end quote, by treating the court's decision as a final settlement of the question of the constitutional right to abortion. Period. That is where that came from. It came from stare decisis, okay, which just means that they look back to prior rulings on the same situation. And it came to these three justices, came up with this situation. Wow, that's crazy. So it actually isn't under any Ninth Amendment or any other amendment people have thrown out there that I've heard over the years. It's actually finally been decided as a final settlement to the constitutional right to abortion by the court's decision. That's all it was. So overturning it's very easy, by the way. So anyway, it says, before us now is one such state law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe and Casey, and once again allow each state to regulate abortion as its citizens wish. On the other side, and this is why I said this was the worst case to bring before justices, because of the position the respondents put them in. On the other side, respondents and Solicitor General asked us to reaffirm Roe and Casey, and that they contend that the Mississippi law cannot stand if we do so. Allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, quote, would be no different than overruling Casey and Roe entirely, end quote. Brief for the respondents is 43. They contend that, quote, no half measures, end quote, are available, and that we must either reaffirm or overrule Roe and Casey. Boom, period. The people who put this before the court and gave the justices basically an ultimatum did this, just so you know. So it says, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. There it is, 14th Amendment. That provision has held to guarantee some rights that are not mentioned in the Constitution, but any such rights must be, quote, deeply rooted in the nation's history and tradition, end quote, and, quote, implicitly in the concept of ordered liberty, end quote. The right to an abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment protection of liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in the past decisions involving matters such as intimate sexual relations, contraception, and marriage, but abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life, and what law now before us describes as an, quote, unborn human being, end quote. So I'm going to jump to page 64. Let's see. Follow me here for a minute. Takes a second to figure out where I had this stuff. It says, the Casey plurality also misjudged the practical limits of the court's influence. Roe certainly did not succeed in ending the division on issue of abortion. On the contrary, Roe, quote, inflamed, end quote, a national issue that has remained bitterly divisive for the past half century. And then it says, Roe may have halted a political process, prolonged divisionness, and deferred stable settlement of the issue. And for the past 30 years, Casey has done the same. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, in this case, 26 states expressly ask us to overrule Roe and Casey and to return to the issue of abortion to the people and their elected representatives. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about a permanent resolution of a national controversy simply by dictating a settlement and telling people to move on. Whatever influence the court may have on a public attitudes must stem from the strength of our opinions, not an attempt to, quote, exercise raw judicial power, end quote, which if you go back and read some more of this, raw judicial power that he's referencing is White's dissent, and White's dissent is a justice, basically said that the raw judicial power is what gave the constitutional power in an abortion, saying that the abortion is a constitutional right. That was the court exercising raw judicial power, overruling any other law in the country that legislative bodies had the right to. That's what that's referring to. Anyway, we do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what would happen, we would have no authority to let our knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. And then it says, we must now decide on what standard will govern if state abortions regulations undergo constitutional challenges and other laws before us satisfy the appropriate standard. Under our precedents, rational basis review is the appropriate standard for such challenges. As we have explained, procuring an abortion is not a fundamental constitutional right, because such right has no basis on the constitutional text or in our nation's history. It follows the states may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, the courts cannot, quote, substitute their social and economic beliefs for the judgment of a legislative body, end quote. That respects for the legislature's judgment applies even when the laws at issue concern matters of great social significance and moral substance. Then I want to go to 67, and this is where it ends. There's a bunch of appendix of history on what they're basing this on. It says, let's see, we end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey aggregated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Period. End of story. So 67 is actually the last part of his actual opinion. So that really answered the question, obviously, of why this whole situation fell under the 14th Amendment. I thought it was a different amendment. Beside the point. It never did. It was just how the court interpreted their opinion using raw judicial powers. And that was referenced earlier, like I said, and I explained it later. Falling back on stare decisis as well. So, interesting situation here. I have a feeling that SCOTUS will be coming out fairly quickly with their final opinion, no longer a draft. If Roe v. Wade gets overturned, people are going to light their houses on fire. Why? I don't know. I have to seriously say, I don't understand why people feel abortion is the hill to die on. I don't get it. People use abortion for legitimate reasons, and then there's people that I went to high school with that used it for basically for purposes that were like, instead of contraceptives, let's go ahead and abort this kid. There was a girl that I knew in high school. She had 4 abortions that she literally said, I would rather have an abortion than have the guy use a condom. Really? So there's people who abuse everything in our country, no matter what it is, okay? But abortion should not be, for one, has to do with someone else's life. And that is why I don't understand why it's a hill to die on to say, I want an abortion. I think it's a hill to die on for people who are against abortion, that say that it's, you're killing the innocent life of a child and all this stuff. I think that's probably the right hill to die on for those people. But the people that are willing to die on the hill to get an abortion makes no sense to me whatsoever. Like, period. End of story. No idea. I don't get it. And saying that it's women's reproductive health is probably the dumbest thing I've ever heard. That it's women's rights, also dumb. Women's health care, retarded. Like, any way that you can categorize an abortion sounds ridiculous. I am for abortions when needed. Meaning, rape, incest, you're gonna die, okay? The mother's life is in jeopardy. Those types of situations. I'm not in it for contraceptive, if you will. I'm really not. So, and the thing is that I thought would come up in this opinion, and it didn't, was science. And the reason science didn't come up is because that's not what was before the court. But if a case was brought before the Supreme Court contending some sort of law that had science behind it and everything else, it would have been an interesting opinion and court ruling, because as we know, science has evolved. And if you follow the science, then you'll be able to tell that within 6 weeks there is a heartbeat. There is, anything further down the road, the fetus actually feels what's happening to it. Like, it's so science has greatly evolved since Roe v. Wade, since Casey, all these things. So if anything, someone could bring before the court, hey, you're actually murdering somebody because that person is a somebody. That fetus exists. So I'm surprised that type of situation didn't come up before the court. But I'm not. Like I said, there's no law that out there that would contest any of that. But I mean, logically, that's where people should fall. If you're for abortions, then at least fall behind something that is legitimate. But you can't. No matter if you're for abortions generically, you're gonna have to tell me why I'm wrong, I guess. Because I think it's just disgusting and it's sick. And don't open your legs and don't insert stuff if you're not ready to have a kid and you're not willing to use contraceptives or whatever. And if you accidentally, quote unquote, have a kid, well, guess what? That's life. Deal with it. There's such a thing as adoption. This is Are You Ready For It? Take care, guys. Have a great night.